This one's wild. Gabrielle Smith walks into court facing a second-degree felony for assaulting a peace officer. But that's not all. The prosecution has re-indicted the case, meaning they hit the restart button after finding something new or wrong in the old case. Why risk reopening it unless they're confident? Watch closely, because this case swings between hope and disaster, and by the end, one decision could change everything.
Mr. Kimler, you've got Gabrielle Smith.
Hold up, did you catch that? A re-indictment. That means the prosecution hit the reset button and brought the case back, usually because they've found new evidence or spotted a flaw in the old one. In legal terms, that's like upgrading the same crime to version 2.0. But why? Let's dig in.
So was this a re-indictment?
Yes, ma'am, that's what I was going to tell you.
Is it going to show up here? It says it was.
Let me show you. This is what he filed in the original case, and then they re-indicted the case in the bond, switched over to that one.
So can we get this to show up now in the original? I mean, in the new case?
I can ask him to either redo it, or I can, yes, ma'am, I can get it in there.
Okay.
I will do that.
Okay, let's see. You are Gabrielle Smith? Stand up, please. And this is...
Here we go, assault on a peace officer.
Assault on a peace officer. Those 5 words can destroy your future in Texas. We're talking 2 to 20 years behind bars. Yet, look at Gabrielle. No panic, no visible fear. Is that confidence or denial? Some defendants hide their nerves well, but that calm face in a stormy courtroom says a lot. What do you think? Is she prepared or just numb after a year in jail?
That's no minor accusation. In Texas, that's a second-degree felony with real prison time on the line. Yet look at Gabrielle, calm, collected, almost unfazed. Either she's been here before, or she knows something the rest of us don't.
Clause number 25, DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct?
Yes.
Ms. Smith, the best you can, raise your right hand. Do you swear or affirm the other one? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now as far as trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have one. I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
And yes, sir. Just here. Ready to get my charges, I guess. Decided.
Do you think that you could post a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
Yes. Two, three, yeah, that 2,3D, 60 or 1030.
Like, such a big crooked dimensional bonds. Okay, let's see.
Every time something happens, at least a steady thing, man.
So, it looks like okay, there was a...
And now, the bond roller coaster begins.
And here comes the bond roller coaster. Raised, reduced, forfeited, reinstated. This woman's bond history reads like a soap opera. But in law, every bond change tells a story of trust and accountability. When a defendant fails to appear or violates conditions, that bond doesn't just vanish, it speaks volumes. Judges remember patterns, and so do prosecutors. Once trust is broken, good luck convincing them twice.
Police lights flash, and the judge starts retracing every up and down, reductions, forfeitures, rejections. It's like scrolling through a messy relationship history. But here's the catch: every bond change tells a story about trust and how Gabrielle may have broken it.
Back in February of 2024, there was a bond forfeiture, and so the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
She then entered a plea, Your Honor. You
Entered-
said a PSI bond.
I did
That plea
at
was
one-
then rejected by the court.
okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess, or?
for a PSI, I reduced it to 1,000. And then appears as though in February of this year, I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out.
What if it's sufficient?
Okay. And then, let's see, let me look at this PSI, that'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000, so I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report,
Court
She-
revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you rejected them.
right, and several misdemeanor thefts and a revocation. Been to prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at 40,000.
Now the real courtroom chess begins. The defense argues Gabrielle never struck the officer directly, that it was all about the car in motion. The prosecution, however, sees assault. This moment is what makes law fascinating: intent versus perception. Did she mean to endanger the officer, or was it a chaotic misunderstanding? Comment below. If you were on the jury, how would you see it? Reckless act or desperate mistake?
Motion denied. Just like that. You can feel the air get heavier in the courtroom. Gabrielle's shot at freedom? Shut down, for now. So here's the question: would you risk going to trial after that, or take the plea deal? Let me know what you do, because things are just starting to heat up.
On a robbery with that criminal history. Okay. Mr. Nichols, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge. But as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. It involved a vehicle. I think where the officer had leaned into it and then the vehicle went into motion. And,
Well, how did the vehicle go into motion?
Well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or bit an officer.
He scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about, I suppose.
So over here in a car with a paper tag from Louisiana, which is where all the other criminal history is. That motion's denied.
Okay, we've got a speedy trial, I guess, so we get it tried.
We're in the 252nd, everything's speedy.
All right.
It will be placed, I mean, is it? It wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all
Well,
the,
I guess if the court has rejected the plea offer, then the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
You can take 8
Take 8. You want me to do a rejection?
and still be.
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Okay, again, you're Gabrielle Smith. And Ms. Smith, in cause number 25, DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer from June 10th of 2023. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Judge,
And I think-
nothing's been filed at this point, but I know with the number of priors she has and a note on the file that the priors have been ordered, I do anticipate there'll be a notice. I forget if it's Mr. Smith or Mr. Muffino, but I know they intend to enhance it.
So I want to make sure you also understand, and I'm going to make a notation on here, if any of those prior offenses out of Louisiana, the felonies, were at different times, and one conviction happened and then another conviction happened later, that means you could be considered a habitual offender and with a minimum punishment of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
This is where things escalate. The judge drops the bomb. Texas's habitual offender law, 1 prior felony can double your sentence. 2, and you're staring at 25 years to life. It's not just what you did, it's what you've done before. Gabrielle's past in Louisiana suddenly becomes the ghost, haunting her future. The judge's calm tone hides the truth. This isn't a routine hearing anymore. It's the fork in the road to freedom, or decades behind bars.
Also, just in case they're not one after the other, if you have 1 prior felony conviction, then, okay, it doesn't do anything. Right, this is a second. All right, so if you have 2 sequenced, it would make you habitual. Do you understand?
If she has 1, it would boost her up to a first.
Yes, sorry. So if you have
I'm
1,
still not understanding what they mean.
okay, so listen very carefully. You have several felony convictions out of Louisiana. Okay, so if just one of those is true, then your punishment range in this case, if you're found guilty, becomes that of a first-degree felony instead of a second. So that means it would be from 5 years minimum up to 99 years or life.
Now this is the bombshell. The judge starts explaining Texas's habitual offender laws. 1 prior felony? The stakes shoot up. 2, you're looking at 25 years to life. It's not just about what you did, it's about what you've done before. Texas doesn't just punish the crime, it punishes the pattern.
If there's 1 prior conviction, you understand? Answer out loud. So
Yes, ma'am.
okay. If there's 2 prior felony convictions that happened, not all of the, I know there were several that happened at the same time, right? But I'm not sure, but it looks like there might be another set that happened later. If that is true, and there are 2 that happened at different times, then it means you could be considered a habitual offender here in Texas. And if that all is true and you're found guilty, then your minimum punishment is 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
Okay. And it looks like what the state has offered, if you wanted to enter a plea of guilty, would be to go on count 1, which is just the offense that you're charged with now, for an 8-year term in prison. You have every right to reject that and have your case go to a jury, let them decide if you're guilty or not, and then let them decide your punishment, depending on what they find on those priors. I just want to make sure you understand what your options are if you wanted to plead guilty for that 8 years, and what your possible consequences are if you go to trial. Do you understand all of that? Okay, and do you want to reject that offer and have your case set for trial?
Yeah, I want to reject.
Okay, and I do want to make sure you understand, Ms. Smith, that after today, unless there is new information or evidence that comes up that the attorneys don't know about at this time, I will not accept this plea agreement after today. So if you change your mind, it's not going to be to the 8 or something less later. It's going to be something different. Once a case goes on my trial docket, it goes.
Here it is, Gabrielle's final lifeline. 1 week. That's all she gets to decide: gamble her life before a jury, or take the 8-year deal on the table. Imagine that pressure, knowing the clock is ticking on your freedom. What would you choose?
To trial. So it's not we're buying time to try to get some better deal. This is the deal. That's fine that you don't want to take it. I do want to make sure.
I mean, I haven't, so I can't.
So, here it is. Gabrielle Smith has 1 week to decide. Take the 8-tier plea deal, or risk 25 to 99 years if the jury goes against her. One choice, 1 week, 1 life on the line. What would you do? This is why courtroom justice isn't black and white. It's all gray until the gavel drops. If you found this case as gripping as we did, hit like, share your thoughts in the comments, and subscribe for more real courtroom moments and expert legal breakdowns. The next hearing will shock you. Don't miss it.
Think on it and come back.
You can think on it and come back next week.
Okay, that's fine.
1 week, you'll leave it open?
Yes, Your Honor, I'll leave it open for, go for recess.
You have to
prior
decide by next week, knowing all of that. Nothing's going to change between now and then. So now you know everything. Think about it. Talk to any family members that you need to. We'll have you brought back next week and you can decide, okay? I'm going to delete this rejection. If y'all do it again, you'll have to do it again.
And the hourglass isn't empty yet. If you think this was intense, just wait. Next week, Gabrielle returns to court. Will she take the deal or roll the dice? Don't miss it. Click the next video to see this courtroom saga continue. All politics news for you.